is Indian Country Today.
Esquili, yes, Thank you for joining us. I'm Patty Tholahungva. With the warm summer weather comes the danger of wildfires. The Southern Ute tribe in southern Colorado is under stage 1 fire restrictions due to high temperatures along with dry fuel conditions. Some of the restrictions include no burning trash, making a campfire, or setting off fireworks. The restrictions are in place until conditions improve. The pandemic is creating a perfect storm for victims and survivors of domestic violence and dating violence, according to the Strong Hearts Native Helpline. This is occurring because of the shelter-in-place orders, which makes victims stay in homes with their abusive partners. In response to this, the group is opening up an online chat room on its website. Users don't need to download an app or any software. They can simply log on and be connected to an advocate to get help. The Strong Hearts Native Helpline offers culturally appropriate services to Native Americans. To access the chat room, you can visit their website, strongheartshelpline.org. Again, that's strongheartshelpline.org. Now for the latest numbers of positive COVID tests in Indian Country, let's go to Jordan Benabigay, our Washington editor. Jordan?
Patty, So as of this morning, there are a total of 4,372 positive confirmed cases and 133 deaths within the Indian health system. Again, that is 4,372 cases and 133 deaths within the Indian health system. And again, this data is according to Indian Country Today's database that we're keeping track of. Indian Country Today includes all the numbers from emails that the staff is getting, social media posts that are confirmed with the tribes themselves, press releases, as well as Google form submissions that are submitted to the staff itself. And Patty, a lot of these cases, they come from the Navajo Nation. They saw an additional 82 cases, as well as 2 additional deaths. And the Mandan, Hidatsa, and Arikara Nation in North Dakota have 2 more cases that they reported. And the first case actually for a tribe in Minnesota is the Leech Lake Band of Ojibwe. They had their first case that was reported. And in the past few days, Oglala Sioux in South Dakota on the Pine Ridge Reservation reported 2 more cases within their community.
We're just seeing this number grow, and do we have any idea on how many tribes are actually being able to test everyone and not just people who have symptoms?
Right now, the only one that I'm aware of is the Wind River Reservation. They have different clinics on the reservation. That reservation has the Northern Arapaho and Eastern Shoshone tribes. And when I talked to the director of nursing, she was saying that at the point they were 2 weeks ago, they're testing anybody who would want to be tested. There are still some tribes who are not getting testing, as if, for example, a tribal chairman in California said their clinics don't have the ability or capability to test right now.
So that continues to be a hindrance for many tribal nations, being able to test all of the people in that tribe. So explain the COVID-19 syllabus that Indian Country Today has created, and where on there can tribes use that Google form to give us that information on positive tests?
Yes, so on our platform, when you come to a platform, you can swipe left 3 times and you'll come to the COVID-19 syllabus. That syllabus has our COVID-19 tracker of all the cases with the spreadsheet and the numbers presented themselves, and also individuals or tribal leaders or health officials can submit cases to the Google form on there using a little button. And it has also all the COVID-19 coverage from Indian Country Today, as well as op-eds submitted from individuals that are related to COVID-19, and other resources that people may want to look into, such as the CDC guidelines, the Indian Health Service, the tribal epidemiology centers, and much more too.
And there's also a map on there that you can click on. It's interactive, so you can see the different locations in Indian Country where positive cases exist.
Correct, yes. And that was made by Talia. She's an epidemiologist who was from Harvard University, and Johns Hopkins.
All right, Jordan Benbigay, thank you.
Yeah, Patty.
And we'll be right back. Welcome back. It's a matter of criminal jurisdiction in eastern Oklahoma and jurisdiction over Native American defendants on tribal lands. The case is known as McGirt v. Oklahoma, is now being decided by the U.S. Supreme Court. The question the justices are tackling is whether or not Congress disestablished the Muscogee Creek Reservation in Oklahoma. Due to the coronavirus pandemic, the 9 judges from the nation's highest court heard this case from their homes. And in an historic move, the case was also streamed on C-SPAN, giving the public for the first time a chance to listen to the case involving tribal sovereignty without having to travel to Washington, D.C. Joining us today is Jonadev Chaudhary. He is the ambassador for the Muscogee Creek Nation. Welcome, Ambassador.
Hello, it's Stungo. It's always an honor to join you at Indian Country today.
Well, thank you. Let's start from a historical perspective. Give us the history of the Muscogee Creek Nation. How did your people end up in what became the state of Oklahoma?
Well, prior to contact, we were the significant tribe in the southeastern part of the United States. North of us, we had Cherokee and Cherokee Nation, and to the west, there's Choctaw, Chickasaw, to the south, Seminole. But we originally come from Georgia, Alabama, and northern Florida. We were removed to Oklahoma, at the time it was called Indian Territory, on the Trail of Tears, along with the other nations that are sometimes referred to as the 5 civilized tribes.
And so when you were removed to, again, what became the state of Oklahoma, were you given reservation land?
Sure. From the earliest days of the United States, our nation-to-nation relationship with the United States has been central to the American story. We were among the first tribes to enter into a treaty with the United States after enactment of enactment of today's Constitution, what we know as the United States Constitution. So in 1790, we entered the Treaty of New York, which helped delineate the bounds, the metes and bounds of the United States in the southern part of the United States. So we've been part of American history from the get-go. That treaty helped give the United States legitimacy on the world stage as a nation itself that can treat with other nations. And we've entered into a number of treaties since then, one of which is the Treaty of 1866, which is central to the Oklahoma versus McGirt case.
And what did that treaty establish?
Well, it established in exchange for huge swaths of land, boundary for our reservation that would never be disturbed.
And was that reservation ever disestablished by Congress?
No, there is a clear line of cases known as the solemn line of cases that grow out of the plenary power doctrine of Congress, the plenary power of Congress doctrine. Essentially, those cases say that Congress and only Congress can disestablish or diminish or undo a reservation. And so the law is clear. Unless Congress affirmatively acts to disestablish a reservation, that reservation remains. From 1866 on, Congress has never acted to disestablish our reservation. So our reservation has been maintained according to the boundaries of the 1866 treaty in full force and effect.
And is that the case for every single tribe in the country that has land in trust? It's Congress that puts that land into trust, and then Congress that can take that land out of trust.
Well, land being in trust can be an important part of whether land is reservation land or not, but under federal Indian law, the term reservation has its own unique meaning. Creek Nation, through treaties, as well as through the heart of the treaty, the cessation of major swaths of land in exchange for undisturbed reservation boundaries, clearly has a reservation, and that reservation has never been disestablished by Congress.
It's very intricate history here in this case. But it also is a shared history for a lot of tribes being impacted by a lot of different federal policies. And so in your case, the tribe being removed from traditional homelands into what is now the state of Oklahoma. The Removal Act of the 1830s that went on into up until the Civil War. And then the 1889 Allotment Act. Do you care to talk about any of those acts or subsequent acts?
Absolutely. Obviously, the case itself most directly impacts Muscogee Creek Nation because we're dealing with jurisdiction over criminal defendants on Indian lands. But the issues involved in the case do potentially impact other tribal nations. In yesterday's Supreme Court argument, there was some discussion about the impacts of allotment on reservation status. And I was pleased to see that many of the justices pointed out the illusory nature of the argument that allotment somehow destroys or disestablishes reservation. As natives living in Indian country, we know that to be true. If allotment destroyed or disestablished a reservation, most of the reservations that we know of today as Indian country wouldn't exist. You have large reservations in the Southwest, such as the Navajo Reservation, large reservations in the plains, such as the Crow Reservation, that were partially allotted. So the notion that allotment by itself is a driving factor in disestablishment, that's absolutely absurd. If that was the case, that would throw Indian country as we know it into complete chaos. And so it was good to see that those arguments were, I don't want to say that they were completely dismissed, but I think they were put into their proper perspective.
All right. So, and overall, the impressions of hearing the case before the Supreme Court yesterday, your thoughts on that?
Well, I want to commend you and Indian Country Today for framing the case correctly. When you said this case is about criminal jurisdiction over Indian defendants, that's all this case is about. There's been a lot of sensational rhetoric from various commentators and at key times the state of Oklahoma itself about what this case is that go far beyond what the case is really about. There's been rhetoric suggesting that this case is really about jurisdiction across the board over Creek Nation and all of eastern Oklahoma. There's been rhetoric that this case would result in thousands of defendants running wild if the Supreme Court upholds the solemn test. All of that is sensationalist and unnecessarily sensationalist. What this case is about, it's simply about the ability of the federal government as well as the Muscogee Creek Nation to adequately prosecute crimes committed by Native American citizens on tribal lands. And so the vast majority of people in Creek Nation boundaries, as well as Oklahoma itself, will be unaffected when the Supreme Court rules in favor of Creek Nation. And so thank you for framing the issue properly, because the alarmist rhetoric that's out there really detracts from the legal principles that are at play in this case.
Well, it is again another indication of just how regulated Indian country is, and what tribes go through with jurisdictions, even intergovernmental agreements with police forces. So there's so many. It is such a well, it's at the Supreme Court, so it's a huge case. In 100 or 1.8 million people live in eastern Oklahoma. So rightly, people are wondering, how is it going to impact me if I'm not a Native American?
The short answer is very little, if at all, because as I mentioned before, this case involves criminal jurisdiction to prosecute crimes committed by Indians, as Indians are defined under the law. And under the law, that means citizens of recognized tribal nations. And so the the jurisdictional landscape of Indian country is very complex. It's often referred to as a jurisdictional maze. And you have a variety of federal statutes that apply to different types of crimes committed by different types of people. The issue in this case simply involves the ability to prosecute Indians on Indian land. Let me add to that, it's very important that Creek Nation and all tribal nations are vested with this authority. Tribal nations work regularly, just like Creek Nation does, to enter into cooperative agreements with state and local governments. There are a variety of cross-deputization agreements in Creek Nation as well as tribes throughout the country. Working cooperatively is one thing, but no government will have a greater interest in protecting citizens and non-citizens alike than a tribal nation who is trying to protect public safety, health, and welfare within its territories. And so ensuring that tribes have the authority to actively, aggressively prosecute wrongdoing in Indian country is very, very important. They can do that in conjunction with state governments, but without that authority, they're left to request other authorities to actively prosecute these crimes. This is very important when it comes to violence against women, when it comes to prosecuting child crimes, when it comes to prosecuting anything that disrupts the public health, safety, and welfare. So ensuring that the local communities, namely tribal nations who are closest to the issues at hand, have authority to prosecute these crimes is critically important. And whether you're native or non-native, you should welcome the greater attention that a favorable ruling will provide to prosecuting these crimes in Indian country. We're fighting to protect the people within our borders, and we'll do everything we can to do so.
Well, one of the justices asked a question that pertained to race. Does this case center around race?
Not at all. As I mentioned before, this case involves jurisdiction of a tribal nation to prosecute crimes committed by Indians on Indian land as defined in the law. In the law, when it comes to criminal jurisdiction, the law is clear. When you're talking about Indians, you're talking about enrolled members, citizens of federally recognized tribal nations. So when you're talking about what laws apply to whom, there's a whole series of of statutory law, one of which is called the Major Crimes Act, that specifically says which jurisdiction has authority to prosecute crimes committed by enrolled members of federally recognized tribes. And as our reservation has never been disestablished, we want to clear we want to address all crimes within our jurisdiction, and we hope the decision in McGirt versus Oklahoma brings further clarity to the boundaries of our reservation so that we can work with our partners to go after bad guys.
Well, so I think for some people, it might not be clear that this is not a case of race when you're hearing Native Americans and non-Native Americans. Explain how, what is a tribe, and if it's not a racial group of people?
Well, the federal Indian law is based on the acknowledgement that tribes pre-existed the United States. Long before the United States existed, tribes as governmental entities, as nations existed. And in the early days of the formation of the United States, it was Congress as a central authority that was given given the responsibility to deal with other tribal nations on a nation-to-nation basis. So when you talk about what tribes are, you're talking about how federal Indian law has grown to recognize the nation-to-nation relationship between the United States and sovereign Indian nations. That's critically important when it comes to jurisdiction, because jurisdiction comes down to governmental authority. And as a government, the Creek Nation administers services, it provides enrollment, It decides who is or isn't a tribal member, as any sovereign does, and it ensures public safety. That's what all governments do. And in order to recognize the importance of this case, you have to recognize the importance of understanding where tribes fit as governments, as sovereign governments within the larger federal legal system. And that's what this case is about.
So tribes being political entities.
Yes, absolutely.
So I think, again, really trying to, it's almost like an Indian 101 course in trying to understand the background of this case in the jurisdiction, and then, what's going to happen. What is the worst case scenario for this McGirt case?
Well, the worst case scenario is the court, fueled by alarmist concerns, somehow carves out a judicial exception to longstanding Supreme Court precedent. Carving out a judicial exception would have damaging impacts throughout Indian country. It would disrupt longstanding federal principles. It would bring a lack of clarity in all dealings, whether it's commercial dealings or governmental dealings with tribal nations, and it would destroy what we understand as the word what we understand the word reservation to mean.
Okay, and give us a concrete example of that.
Well, if a tribe doesn't have a reservation, it doesn't have governmental authority to protect its citizens and and other non-citizens within its borders. A government protects its people. A government protects its people through having jurisdiction over defined lands. If you diminish or destroy the word reservation, you diminish and destroy jurisdiction, and diminish and destroy the ability of a government to prosecute crimes, to enact laws, to protect the most vulnerable, to provide important programs and services to the most vulnerable. If you destroy a nation's land base, you destroy its ability to protect its citizens and everybody within that community.
Okay, that sounds pretty terrible. I think really putting that into perspective and understanding what could happen in the outcome of this case before the Supreme Court. There are a number of people who have sent in, I'm blanking on the official term, support for the McGirt case.
Oh, amici, yes. So members of Congress submitted an amicus brief led by some of the longest serving and most respected members of Congress, including Congressman Tom Cole. The National Women's Indigenous Resource Center submitted an amicus brief highlighting just what I spoke about, that if you do not allow a nation to protect its citizens through enforcement of its reservation boundaries, you remove the ability of tribes to enact domestic violence laws, child protection laws. You're not able to give effect or life to the Violence Against Women Act within those laws. And the Murphy case, as with McGirt, U.S. attorneys from around the country have talked about preserving these bedrock Supreme Court precedents to avoid chaos in Indian country. There have been numerous friends of the court briefs, as they're called, amicus, Latin for friendly, that have been submitted, all showing that adherence to the Supreme Court precedent set forth in solemn is critical to maintaining law and order in Indian country.
All right.
When you asked about a worst case scenario, the creation of a judicial exception to the solemn line of cases would be devastating to Indian country.
All right. Well, Ambassador, thank you so much for joining us today on our broadcast.
Okay, thank you for having me, and my heart goes out to all sister nations that are dealing with this COVID crisis, we stand with you. Our hearts are with you. We stand side by side.
Yes, it's definitely something we're keeping an eye on in Indian country. And we appreciate you joining us today as well. We wait for the Supreme Court decision. Who knows when that will be, but hopefully by the end of the summer or early fall. So thank you for joining us.
Okay,
And
thank you.
yes, take care of yourselves. Your life is precious. I'm Patty Tholahungva. Thank you for joining Indian Country today.
This is Indian Country Today.